What family law judges notice about you that nobody tells you? Going to trial and being on the other side where someone is self-represented just tells it all. And how you can lose custody. There is a saying, you speak louder than any words you're saying. What it means is the attitude in courtroom matters. For example, if one parent shows up and says, I want sole custody because mom is always late to visitation, she cancels appointments to doctor, or she doesn't even notify me, although we have joint legal custody, about appointments to the doctor. So I want to have sole custody about all appointments to the doctor. And many, many more accusations. And provides a really detailed, by date, proof of those accusations. Not proof, but accusations. And then this person shows up, let's say it's dad, and starts disregarding judge's instructions. For example, if they testify, they cannot answer a question, yes or no question. If, for example, asked, well, didn't you receive the text message via family app, let's say parenting app, about this particular doctor visit for this particular child on this particular day? And they cannot say yes or no, even though it's black and white that they did. They're like, oh, mother is always doing this and always, and they're using these words always and never. That's another no-go type of words. And so I would answer only specific question. So in that kind of case, and that father, for example, would object to every single question asked to the witness. Objection irrelevant, objection vague, objection confusing, even though the objection is not legitimate. And so in that type of case, the judge would say, well, if that parent disregards my instructions, cannot answer, evades simple questions, how would that parent act with small children? And that parent is asking for sole custody, even if the mother did partially what that parent said she did, that does not justify sole custody, and that attitude in court doesn't justify any change in custody. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. So what type of lesson to learn from how to behave in court? First of all, listen to the question the court is asking carefully and answer the question asked. It's very tempting to not answer that question directly because there's so many things you would like to clarify, and especially if the question is really tricky. Well, isn't it true that you canceled that doctor appointment on that day? Well, you canceled it because you were sick, but that wasn't the question. Yes, you canceled it. It's true, I did cancel it. And I can clarify why, and the judge might say, no, I'm not interested. You canceled it, right? So, number one, answering questions that being asked directly, and then your attorney on cross-examination would have a chance to clarify, well, you said you canceled. Was there a compelling reason why you did so? So your attorney will recover, so to say, bad testimony on a cross-examination to give some context. Answering question directly is number one key. Number two, respecting judge's instructions. For example, if judge says, well, I'm sick and tired of you objecting every question, then stop objecting every question. Just object to questions that are really to be objected to, not just to every question. It's disregarding court's instruction. It disregards the trial length. It disregards a lot of things. So do not overuse objection. Another point is to dress appropriately. For example, the court looks at the totality of the personality. So if someone respects the court, I would say don't dress like you're going to a ball, but don't dress in sweatpants. So it's sporty, casual, more what your typical style is. I wouldn't suggest you dress as a client with a suit and a tie. That's just too confusing with your own lawyer, if it's a male lawyer. So first of all, attitude, respecting boundaries, respecting time. Sometimes courts say, well, you only have 10 minutes to talk. Well, guess what? Put a timer, have you fill your 10 minutes, because if you talk for 20 minutes, just those little things that add up to a big picture. And the court notices everything. So your attitude, how you dress, how you respect boundaries, how you behave towards the judge. If the judge is talking, it seems obvious, but don't interrupt the judge. You don't want the judge to be mad at you for being disrespectful of the judge, who is the one making decisions about your situation. Overall, I suggest to have an attorney. It's very obvious when I see when self-represented parties overuse objections, disrespect the boundaries, say things that are completely inappropriate, file motions half an hour before the trial, saying the whole trial should be set aside because they couldn't hear things, while at the same time they were the ones objecting to every question. So lawyers have an ability to filter logic, sense, law in one, and I would make sure before you go to trial to have a very strong either consultant, or just don't go to trial without a lawyer. I know it's easy to say because trials are expensive and not everyone can afford a lawyer for a trial, especially when it's several days, but at least having someone consulting and follow those instructions could mean a lot. It could mean sole custody or no custody sometimes. I hope this video was helpful, and I'll see you in my next consultation. Bye!